Let's get rolling so we all have time to eat something today. First, I will call the hearing of the Judiciary Finance and Civil Law Committee back to order. We'll pick up where we left off. Representative Curran, you ready? Yep. All right. Representative Curran would like to move, so I will move House File 3860 before this committee. We're going to lay this one over. Representative Curran does have a DE1. Would you like to move the DE1?
Yes, so moved, Chair. Thank you.
All right. All those in favor of the DE1, please say aye.
Aye.
Aye. Opposed? All right. Motion prevails. The bill is now in the shape you would like. Representative Curran, please tell us about your bill.
Thank you so much. I know we have a lot on our agenda. I'll keep it brief. So House File 3860 would establish a State Board of Civil Legal Services, and I will turn it over to our testifier to provide details.
All right. Please introduce yourself for the committee and proceed.
Thank you, Chair Becker-Finn, Representative Curran, members of the committee. My name is Luke Grunman. I'm currently serving as Interim Executive Director at Mid-Minnesota Legal Aid. And I don't think anyone on this committee needs a long introduction to what civil legal aid is. We represent thousands of Minnesotans every year. We help families get out of abusive relationships. We help seniors get their money back from fraud and much, much more. This bill is about oversight and accountability. The legislature appropriated significantly more funding to civil legal aid last year. We need to make sure that money is being spent properly. Until now, the Supreme Court was charged with oversight. It did so through a well-functioning advisory committee, but the task now requires more resources. This bill would create a new board. That board is modeled after the Minnesota Board of Public Defense. It has many advantages. It could allow additional staff positions to be hired to help with the oversight. It can create new quality control standards. It could allow better site visits to be conducted and more controls on that. A separate board would be able to better focus on the task of oversight. Civil legal aid has been in this state for 111 years. This new structure could help ensure that it stay in place for many more. So this bill, as I said, is about oversight and accountability. My organization, Mid-Minnesota Legal Aid, would be one of those organizations subject to oversight. So you might say, why is legal aid advocating for this bill? Well, I'll tell you, we welcome it. It's legal aid, we are proud of our work. We want the opportunity to demonstrate how proud we are of it, and this board would help us do that. So I know the committee has had a lot of testimony already today, and we're on our second part of the session. So I will keep it short, but happy to help the representative answer questions. Thank
And I do procedurally, I had my notes wrong. It was actually the DE2 amendment. So I will move a motion to reconsider the previous motion. All those in favor, please say aye.
Aye.
Opposed? All right. Representative Curran, would you like to amend your motion to move the DE2 amendment?
Yes, thank you, Chair. That is my amendment to the motion.
Okay. All those in favor, please say aye.
Aye.
Aye. Opposed? All right, thank you. Thank you, staff, for catching that. Are there any other members of the public wishing to testify on this bill? Not seeing any, we'll move on to member discussion. Members, any representative? Oh, I'll let you have the last word, Representative Scott. Representative Carroll.
Thank you, Chair. And I just have a question for the author. What took so long? I'm shocked. I know we don't have one, but we certainly do for public defense. And I've dealt with a lot of folks, a lot of low-income folks who need help, and there's just not sufficient resources or people willing to do it. So thank you for doing this. But anyway, what's the answer?
Representative Curran.
Thank you, Chair. Thank you, Representative Carroll, for your support. This is the first time that this bill has been presented to me in my first term. So as far as what took me so long, I just got here. But I would love to give credit to those who've been doing this work for a long time through Chair Becker-Finn, and we've been enhancing these things, as we know, year after year, and certainly have seen a push for this. So now it's time to pass it.
All right. Representative Johnson.
Chair Becker-Finn, Representative Curran. I got a couple questions. One is, or I should say the first one, Can you tell me why the current advisory committee, which is 7 lawyers and others appointed by the Supreme Court, insufficient?
Go ahead.
Thank you, Chair Becker-Finn and Representative. What I would say to that is that the advisory committee has done an excellent job. It really has. The problem is that the Supreme Court has many, many tasks before it. This board would essentially be the same thing as the advisory committee. In fact, you'll notice in the delete everything amendment that the current advisory committee would become the new board as on day one, and then it would allow appointments to replace those members going forward. So there is absolutely nothing about this that is to cast any aspersions on the great work of that committee and the Supreme Court. It's to, what it will allow is for that committee to become an independent board, no longer overseen by the Supreme Court, subject to reports to the legislature directly, and for that greater enhanced level of oversight.
And I can add, as the person who's chaired this committee and gone through a couple budget cycles, that there's sometimes been some conflicts of interest, in my opinion, regarding, because the Supreme Court only asks for so much, and it's sort of pitting them against asking for their own needs versus asking for the needs of legal aid. And this way, legal aid could put their requests straight to us as legislators instead of having it go through another entity who has their own needs as well. Representative Johnson.
Chair Becker-Finn, Representative Curran, thank you for that answer. But I do have concerns with it. I've seen this happening more and more on other boards, Sentencing Guidelines Commission, Post Board, and a few others. With the setup of this board, it appears it's making the board more political, and I'm concerned about that. Are you have any concerns on that as well?
Director or Representative Curran.
Thank you, Chair Becker-Finn, and thank you for the question, Representative. I guess we don't believe that it would make it more political. We think that, as you pointed out, there's been some great lawyers who've served on the committee, and we would expect the same thing would be true for a board. And I think the work of the board, as we talked about, would be oversight. Like, the idea is they would help us as legal aids to do better work for our clients, to make sure that we're doing the things that we have promised to do. And so there's not anything inherently political about that. It's just helping us do better quality control for our clients.
Any follow-up, Representative Johnson?
Chair Becker-Finn, the testifier, I understand that. But like I said, I have a lot of concerns, because when Post Board and Sentencing Guidelines and a few other boards were set up, it was set up that way. And unfortunately, they've changed dramatically. So I believe it's much better under the Supreme Court, because it seems to work a lot better that way. And so I got a lot of indigestion with this.
Thank you. And I will point out on line 1.19 that the majority of the members of the board would be appointed by the Supreme Court. Next on the list, Representative Grossel.
No, Madam Chair. In that flurry of exchanges, I think the question was answered that I had. Thank you.
Great. Representative Scott, now you're the last one on the list.
Okay, thank you, Chair Becker-Finn. I guess I don't have a lot of questions that haven't already been answered. I don't have any, as a matter of fact. I just think this is an expansion of government that's not needed. I think what we had was fine, and just because we can doesn't mean we should. So I'll be voting no. Thank you.
All right, and we're not voting on it, we're laying it over.
I missed that.
Yeah, yep, oh, yeah, yeah.
I was a little late, sorry.
Closing comments, Representative Curran.
Yes, thank you, Chair Becker-Finn, and thank you all for the discussion. I appreciate the discussion of, looking at government oversight, and are we doing too much of that? I will say, what I see with this board in particular, it is very different from other boards that have been established that look more at policy decisions. This is primarily focused on looking at how we're using the state's money, and gives greater oversight in the use of that money. And so, in that regard, I think that there really is some urgency to this bill to ensure that the board is established prior to any major funding decisions that might be made next session. I think that this board will ensure that funds are used more efficiently than they might be now.
All right. Thank you. With that, I will lay over House File 3860 as amended by the DE2. Next up, I got Representative Feist. Representative Feist, would you like to move to re-refer House File 4157 to the Education Policy Committee?
Yes, Madam Chair, that is my motion.
All right, the bill is in front of us. Representative Feist, please tell us about your bill.
Thank you. This bill authorizes school districts and charter schools to release specific student data to the Department of Employment and Economic Development for the purposes of coordination of special education services under Section 125A with pre-employment transition services for students with disabilities. And I'll keep this short because we are running over. But basically, when we made certain data private under the registry bill last session, we inadvertently created a disconnect, and the Department of Employment and Economic Development would like to make sure that they can reach these students and families and make sure they can provide services. And I will leave it at that.
All right,
Over
and
to
I've
the
got one testifier, Megan Ariola. Please introduce yourself and then go ahead with your testimony.
Thank you, Madam Chair and committee members. My name's Megan Ariola. I'm the legislative coordinator for the government relations team at the Minnesota Department of Education. I'd like to thank the chair and the committee for giving us time this afternoon to present this bill, and to Representative Feist for letting this go through, for authoring this bill so it can come through the committee. This bill is a standalone provision of one standalone provision from the governor's education policy bill. We cloned this provision to just respect the jurisdiction of this committee and ensure that this provision receives its proper review. So the change being requested in Section 13 to the education data provisions of law is to permit our districts to continue assisting our students without being out of compliance with the law. As Representative Feist mentions, this proposal authorizes school districts and charters to release specific student data to DEED for the purposes of coordinating special education services under Section 125A. These services include a number of things for our students that receive special education during their K-12 experience, including job exploration counseling, work-based learning experiences, post-secondary education counseling, workplace readiness training, and instruction in self-advocacy. The purpose is to ensure that students with disabilities receive information about these services offered to them and that they can access them. Before last year's classification of student directory data as private education data, districts with students receiving special education services that were eligible for these programs they've been relaying that information to DEED with no issue in years past, but right now they don't want to be out of compliance with the law. There's no automatic way for DEED to know which students that are graduating or leaving the K-12 system have a disability, so that they can reach out and let the students know about their rights under these services. Our MDE student database doesn't include any contact information, so the only way for DEED to be able to provide these services for these kids is to allow schools and school districts to release directory information directly to DEED so that they can contact the family and the student. Without these, they just might not they could miss deadlines or otherwise be not accessing services that could help them in their career transition. Thank the chair and the rest of the committee for the time to hear the provision, and I stand ready for any questions.
All right, are there any other members of the public wishing to testify on this bill? Not seeing any, we'll move on to member discussion. Representative Scott.
Thank you, Madam Chair. I just want to verify, put it on the record, that this information was already being shared prior to the changes that were made in the directory information last year. We're just, it was either DEED didn't show up or just wasn't aware of that change and how it would affect them. So we're not gathering any new data, sharing any new data. We're just picking up where we left off.
I see lots of nodding heads, but for the record, Ms. Ariola.
Verbal confirmation of yes, Representative Scott. This should allow our districts to continue doing the work they were doing last year.
Any other member discussion? All right, closing comments, Representative Feist.
This is a good bill. Please support it. Thank you.
All right, Representative Feist renews her motion to refer House File 4157 to the Education Policy Committee. All those in favor, please say aye. 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 Opposed? Motion prevails. Thank you, Representative Feist.
Thank you.
Representative Stephenson. Sorry that we're making you miss your lunchtime.
Sorry, not sorry.
I'm the problem, it's me. I enjoyed my delicious lunch of a granola bar sitting in the gallery. just
They're
now.
better than me today. Representative Stephenson, I will move to recommend House File 3625 be re-referred to the Public Safety Committee. I will note the provision that's in front of why this is in front of us is Section 6 regarding injunctive relief. So if we can keep the discussion and our questions to that provision, why it's in front of us, that would be great. Chair Stephenson, please tell me about your bill.
Thank you, Madam Chair, members of the committee. I'll be very brief. This is revisions to the deepfake bill that passed with broad support last year and really was a nation-leading piece of legislation designed to put some guardrails in place to protect against the emerging threat of deepfakes in our elections and in sort of sexual abuse situations. The provision that brings this before the committee is the availability of equitable or injunctive relief to clarification in Section 6. It's just making sure that we have the ability to try and stop people from disseminating these deepfakes. And with that, I'm happy to answer questions.
All right. Let's see. I do have a couple testifiers signed up. First up, I have David Fisher, and then I have Terry Nelson on deck. Please introduce yourself and correct your name if you're not David Fisher.
This is Mary Hartnett. I am not David Fisher.
Okay.
But I am with Clean Elections Minnesota. He was not able to, when with the.
Okay, well, I will remind you, as he was reminded, you've got 2 minutes. So
Yes, okay,
please
all right.
introduce yourself and go ahead.
With Clean Elections Minnesota, a nonpartisan nonprofit working for an inclusive and healthy democracy in Minnesota. We believe that faith in elections and acceptance of results are essential ingredients of functional democracy. Even now, deepfake AI is turning our U.S. presidential election to a test on the need to prevent the harms of deceptive content in our media. Early this year, thousands of fake robocalls went out for the New Hampshire primary, discouraging people from voting. While robocalls are not new, making a persuasive hoax has gotten easier, faster, and cheaper thanks to generative AI tools. HF 3625 addresses head-on the need to mitigate the pernicious nature of such fraud during the immediate run-up to an election, the last 60 days when there's little time to fact-check or debunk it, by adding additional consequences for violations of the law. We thank this committee and the legislature for their bipartisan work on this issue and urge support for the additional provisions that will strengthen last year's bipartisan bill. And thank you for your work, and thank you for giving the opportunity to testify.
All right, thank you for your testimony. Next up, I have Terry Nelson. Please introduce yourself and then proceed with your testimony.
Good afternoon, Madam Chair, members of the committee. My name is Teresa Nelson, and I'm Legal Director for the ACLU of Minnesota. I have over 2 decades of experience litigating constitutional rights issues, and I'm an adjunct law professor. So first, 3 quick, important First Amendment law concepts. 1, except in limited circumstances, parody and false speech, including false political speech, is protected by the First Amendment. 2, under New York Times v. Sullivan, false statements about public officials and public figures can be punished, including getting injunctive relief, but only if the speech is made with knowledge that the speech is false or with a high degree of awareness of probable falsity. That standard is higher than the reasonably should know standard in 609.771, which is a negligence standard. And 3, content-based restrictions on speech must pass strict scrutiny. The government must have a compelling interest, and the restrictions must not burden more speech than necessary to serve that compelling interest. Now, the underlying statute here is on shaky First Amendment grounds because it has to pass strict scrutiny, and it is too broad because it criminalizes more speech than necessary to serve the government's interest here. House File 3625 doubles down and makes it even more broad by expanding the timeframes for when speech can be criminalized, expanding the penalties, and even more problematic, expanding the content of the speech that can be criminalized. The language starting on line 2.25 essentially criminalizes material that is capable of multiple interpretations. Negligently retweeting a poorly executed parody will become a crime. And that speech doesn't even have to be false. One could graft a video of a candidate speaking using the candidate's actual words taken from other source material, and that would be a crime even though the underlying information is accurate. And so the new language also raises due process concerns because it's vague. It doesn't give adequate notice to people about what speech is going to land them in jail. We already have tools in statute to address intentionally false campaign speech. And to be clear, the ACLU does not oppose narrowly drawn prohibitions on, for example, intentionally false misleading speech about the time, place, manner, or legal consequences of voting that is uttered for the purpose of disenfranchising voters. And so because of the breadth of House File 3625, we respectfully urge you to reject this bill. Thank you.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion, but we'll remind members that we're talking about whether we should add or equitable in the injunctive relief section, starting on line 4.7. Representative Niska.
Thank you, Chair Becker-Finn and Representative Stephenson. I will be brief because my comments, I think, go more towards the constitutional issues about this, which I do think are reasonably within the discussion of this. But just very briefly, I agree with some of the comments the ACLU testifier made, in particular about the new language on 2.25. I do think that can be tightened up. I hope you'll look into ways to tighten that up for sure. But my question for you is, how does this interact with the constitutional provisions that define the eligibility for members of the legislature or define the members of the executive branch when we're talking about disqualifying people from office? And, you know, for example, the legislative provision says the legislature shall, it lists certain qualifications. It doesn't allow the legislature to add to them, and it says the legislature will be the judge of its members' qualifications. So how would this provision work with that provision of the Minnesota Constitution?
Representative Niska, you went outside section 6, but I'll allow it if Representative Stevenson, you can keep it short and we don't continue down this path. Representative Stevenson.
Section 2 relates to disqualified candidates not to hold certain positions. It's important to note that this pertains only to state and local positions, not federal positions, which we can't do for federal constitutional reasons. There are existing law disqualifying candidates who break certain laws from holding office in Minnesota that I believe is statutory and not constitutional. I'm not aware if it's been litigated at the Supreme Court of that existing prohibition. This simply adds deepfakes to that. So there's already violations of what I think is called the Fair Campaign Practices Act is already potentially a disqualifier for state and local office under Minnesota law, and this adds the deepfake provision to that. So I believe it's on square constitutional ground with regard to the Minnesota Constitution, but it's worth noting that perhaps that underlying provision may or may not have been constitutionally litigated in Minnesota.
Representative Niska, any follow-up?
I will just say I hope we can continue to have this conversation. The way I read Article 4, Section 6, it does seem like it's a potential problem in terms of dealing with legislators. On the overarching issue, obviously, this is an extremely important issue. The technology that we're talking about, the potential to really deceive voters, is a real issue. And so, as we discussed last term, I appreciate the fact that you're taking it on, and I appreciate the willingness you had last session to talk, dig into the language and talk about it, and I hope that will continue. I don't think this is quite ready yet. Thank you.
On caucus night, my kid described my job as running from room to room talking to people. And I know that Representative Stevenson is very good at that, so I'm sure conversations will continue. Any further discussion to the bill? All right. Closing comments, Representative Stevenson.
It's a good bill. Please vote yes.
All right. I will renew my motion to recommend that House File 3625 be referred to the Public Safety, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed?
No.
Motion prevails. You still get to sit up there, Representative Stevenson, and you still get to talk with Representative Niska, I bet. I will move House File 3506 before the committee. I understand there is I'm going to double check now since my notes were wrong last time. The A2 is a technical amendment that the author would like, just making some small language tweaks. So I will move the A2. All those in favor of the A2, please say aye. 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 Opposed? Motion prevails. The bill is in the shape the author would like. Representative Stevenson, please tell us about your bill as amended.
Thank you, Madam Chair, members of the committee. I'll start by saying that the House Research Summary, they're always good. This one is particularly good. And so in lieu of going through the bill in detail, I would just encourage everyone to lay eyes on that, because I think it does a good job of explaining the various provisions of the bill. This has to do with how a plaintiff's damages are apportioned and calculated in the event of a judgment in a civil action. It modifies some law that was passed a couple decades ago, and I think that law in the subsequent time has been subject to judicial interpretation that has resulted in some unintended consequences that are materially impacting people who have been harmed in Minnesota. The principle behind the change that we made a couple decades ago to law was people should pay for what they broke, right? That we wanted comparative fault and looking at people just paying for the portion of their damages that they are responsible for. Unfortunately, the way that it has been interpreted and applied in the intervening decades have resulted in a case where people are not getting their harms fully addressed. And that is a problem. And so this bill makes some relatively modest changes to that regime, keeping in place. We're not trying to go back to where we were before 2003, but we're going to try and make some changes to make sure that if somebody is hurt, that they have the ability to recover for their damages.
All right, and I do have a couple testifiers signed up. First, I have Chuck Slane, and then I have Dale Thorns-Joe on deck. And the reason I tell you you're on deck is so that you can move closer to the table, so you can start your testimony sooner. Please introduce yourself for the committee and go ahead with your testimony.
Thank you, and thank you for allowing me to be here and speak today. My name is Chuck Slane. I'm the immediate past president of the Minnesota Association for Justice. As Representative Stephenson said, this bill provides some modest changes to correct some inequities in a law that was changed without any committee involvement at all the last time this was changed. And we'd urge you to pass the bill, and I am available to answer any questions that anyone has that they'd like to discuss.
All right, thank you. Only other person signed up ahead of time, I have Dale Thorns-Joe, and we did allow you can come on up to the table. And I understand you're testifying on behalf of several different people and organizations, so we did allow a little bit longer for your testimony. I appreciate when people coordinate like that. It's easier on everybody that way. So welcome to the committee. Please introduce yourself and then proceed.
Thank you, Chair Becker-Finn, members of the committee. My name is Dale Thorns-Joe. I am a litigator, civil litigator in the southwest suburbs of the Twin Cities. And I've been a past chair of a national defense organization. So I've had a wonderful opportunity to coordinate with a lot of lawyers in a lot of jurisdictions about comparative fault statutes within their jurisdiction. I find it interesting to, and I'm speaking on behalf of myself as an individual, with concurrence from the Insurance Federation, as well as the Minnesota Defense Lawyers Association. I find it really interesting that the presentations so far do not talk about the sea change that this bill will have by creating a liability for a defendant who is less at fault than the plaintiff to be obligated to pay part of that judgment. Minnesota has never, ever had a defendant who is less at fault than a plaintiff pay part of a judgment. And the sea change that happens is the use of the word aggregate, which is now changed to combined. Aggregates in the Iowa statute, Ohio has the combined word. But what it really does is that it creates pure comparative fault, which means the plaintiff can be more at fault than an individual defendant and yet have to pay the portion of the fault that's allocated to them. If it's 50-50, like it was in the Staub case, which is the case that the presenters were talking about previously, under the Minnesota statute, that's 50-50, so the defendant pays 50%. But what if the plaintiff is 40% at fault and the two defendants are each 30% at fault? It has always been the law in Minnesota that the plaintiff not recover anything. This statutory change now allows the plaintiff to recover 60% of their damages, even though none of the defendants were more at fault than the plaintiff. That's not been talked about here. This is a massive sea change. This is bad public policy. I try to be good with what I do, and if a plaintiff ends up suing me, but the plaintiff is more at fault than me, why is it that by happenstance, if another party over whom I have no control might be involved in that same lawsuit, and my liability turns not on my conduct, but turns on the conduct of the other person? I have no ability to be able to deal with that person or protect myself from that person. So there's a fundamental unfairness with that term aggregation with the one section. The concept of pure comparative fault is incredibly dangerous. I've talked to jurisprudence people in multiple states that have pure comparative fault, and they basically say their tort system is broken. There is never a discussion of liability ever anymore. It's always about how much can you extricate from the defendant in order to get out of the lawsuit. And that takes away the liability defense that has been the traditional bedrock of the Minnesota tort system. It's interesting because one of the things that the MAJ had talked to me about was there's 22 jurisdictions that allow this aggregation of fault. So in other words, my 40-30-30 example, if you aggregate that, that's 60%. What they don't tell you, and what they didn't tell me, but I learned from talking to dozens of litigators in the jurisdictions, in a lot of these 22 that they mentioned, is that their comparative fault structure is very complicated. And if you change one piece of it, everything else falls apart. If I can have 30 seconds.
Really quick, because we will also be laying this over, so
Okay.
there'll be plenty of other time for you to talk off the record, but just
Here's some points.
one sentence.
There's a differentiation in how other jurisdictions handle the type of damages, the moral culpabilities, whether or not punitive damages are part of the litigation. And so there's a lot of other pieces where the changes proposed in this bill should be part of a comprehensive review and analysis as opposed to a piecemeal approach on revising this statute.
All right. When staff tells you a number of minutes, I actually time myself at home, so I know how long it's going to take me. Are there any other members of the public wishing to testify? Right, not seeing any. I want to make sure we have time for the amendments. I understand the A1 amendment. Representative Niska, is that your amendment?
Yes.
All right, would you like to move the A1 before us?
Yes, thank you, Chair Becker-Finn. I move the A1 amendment, and in this discussion, I actually would appreciate if both of the attorneys, both of the testifiers would answer the question for me of what happens under Section 2 and Section 4 together if a jury finds a driver who's a plaintiff 25% at fault, the other driver who's drunk 70% at fault, and 5% awards 5% fault to the dram shop, to the server, and the 70% at fault driver is uncollectible. Because I'm concerned, and this is the reason for the A1 amendment, that in that situation, the 5% at fault, bar under dram shop liability is going to get reallocated a very significant piece of their liability. So if either Mr. Slane or Mr. Thornzio could answer that question. Is that how the law works? Is my concern correct?
Everybody loves a word problem not written down in front of them. But Mr. Slane, please go ahead.
Thank you. And thank you for the question, because I think it's a very important point to understand how the entire process works. First step in that equation is that the bar pays 5%. They pay for their fair share. They pay for what they broke. The law then, and this was the law pre-1983 change, that if an amount is uncollectible, it then gets reallocated fairly amongst everyone, including the plaintiff. A plaintiff who is at fault still has to take their fair share of that uncollectible amount. So they're being treated the same as that defendant who caused the injury to the plaintiff. So still, everybody pays their fair share, and most importantly, that's a special circumstance that happens very rarely. And that's why we have this provision that's been in the bill for decades, until the Supreme Court in Staub obliterated it and left it meaningless. And that's why it's important to give it meaning once more.
Please, please go ahead as quickly as you can.
Thank you, Chair Becker-Finn. Representative Niska, very important question. Why should I be 5% liable when the plaintiff is more at fault? That 5% liability has never paid ever in the history of what's going on. Even more importantly, this legislation in an employer as a third-party defendant, for example. So an employee gets injured, sues a product manufacturer or sues a third-party tortfeasor, who then brings in the employer, say they didn't properly supervise, they didn't properly train, this sort of thing. So now you have a situation where it's 25% plaintiff, 5% tortfeasor, and 75% employer. Under a case called Fish, as applied to this aggregate combined section, means the 5% defendant pays the entirety of the employer's liability. In other words, they pay 80%, even though they're only 5% at fault. So they've never had to pay before, and under this provision, they will pay 80%. That's just simply not fair under Minnesota jurisprudence.
All right, any other discussion to the A1 amendment? Representative Niska, closing comment.
Yes, thank you, Chair Becker-Finn. And if I understood your answer, Mr. Slane, I think what that means is that the 5% at fault bar gets allocated that 70% at a 1-to-5 ratio with the plaintiff, which is another 11.6%. So the 5% bar, 5% liable bar ends up with over a 15% liability. And so frankly, I don't think that is people paying for what they broke. I think that is people paying more than what they broke, and that's why I think that 2 and 4 aren't ready yet. It doesn't strike the right balance. I urge members to vote yes, and I request a roll call.
Roll call having been requested. Representative Stephenson, any comments?
Well, first of all, I'd ask members to vote no. And I'd just point out, when Representative Niska was doing the math there, he left off the other half of the equation, which is that the balance of that 70% that's getting reallocated is reallocated to the plaintiff. And so he's concerned about the dram shop going from 5 to 11, but the plaintiff goes from 20 to, I'm not doing the math, but a much, much, much higher number. And so I think what we have to think about in this situation, when an amount is uncollectible, it's not that that harm goes away. It's not that those dollars evaporate into thin air. Somebody is eating the cost of it. And under the current system, that's entirely, all of that burden falls on the injured person, nothing on the rest of the party. That's not fair. If the idea is pay for what you broke, pay for it in proportion. And in a situation where something is collectible, reassigning it equitably is the right solution.
All right, the A1 amendment before us, a roll call having been requested, the clerk will take the roll.
Chair Becker-Finn.
No.
Vice Chair Frazier.
No.
Lead Scott.
Yes.
Representative Carroll.
No.
Representative Curran.
No.
Representative Feist.
No.
Representative. Representative Frederick.
No.
Representative Grossel. Representative Johnson.
No. Oh, yes.
Representative Mueller.
No.
Representative Niska.
Yes.
Representative Weens. 3 ayes, 8 nays.
All right, the motion does not prevail. I'm not going to piss off the tax chair. So when we pick this bill up again, the A4 will still be valid. We're not going to reopen the whole window on amendments necessarily, but you will get your shot to make that argument in the future when we pick the bill back up. Representative Niska.
Any sense on when that might be?
Not at all. It may depend on some conversations that are happening, but it will be noticed the same as we notice everything else in this committee. With that, I will lay over House File 3506, and with that, we are adjourned.